Welcome to the Supreme Court of the United Kingdom, where today we're beginning the hearing of the appeal in the case of FS Cairo, Nile Plaza and Brownlie. I'll be hearing this appeal with four of my colleagues, whom I'll introduce now: Lord Lloyd-Jones, Lord Briggs, Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
The case arises from a road accident in Egypt in which the claimant, Lady Brownlie, was injured and her husband was killed. The accident occurred in the course of an excursion which had been booked through the Four Seasons Hotel in Cairo. And in these proceedings, Lady Brownlie is seeking damages from the company who operated the hotel. The appeal is concerned essentially with two issues, which I can describe very briefly. One is whether Lady Brownlie is able to bring proceedings in tort against the Egyptian company in the English courts. And the other question is whether she can establish that she has a reasonable prospect of success at this stage by relying on a presumption that Egyptian law is the same as English law, without pleading specifically what Egyptian law in fact may be. The hotel company are represented by Ms. Kinsler, Queen's Counsel, and Mr. Palmer, Queen's Counsel, assisted by Junior Counsel, and Ms. Kinsler will be opening the appeal on their behalf. So I turn now to Ms. Kinsler.
Thank you, my lord. My lord, the parties are most grateful to the court for expediting this appeal. Just before we start on legal argument, can I say that on our side of the court, we are, of course, very conscious that this case arises out of the most tragic circumstances. And we all recognise, of course, that Professor Sir Ian Brownlie was a very distinguished scholar and practitioner. I hope you lordships will understand that we, and I personally, have the utmost sympathy for Lady Brownlie. And my lord, I've said as much whenever I've appeared in these proceedings on previous occasions, but I do repeat it here because I wouldn't want it to be lost in the midst of the legal arguments. My lord, the court has our written case and we rely on that in its entirety. The proposed plan for today is I will address the court first on the ground of appeal related to the merits requirement. Mr. Palmer will then address the court on the tort ground. My lord, the issue on this part of the appeal is whether the claimant has established reasonable prospects of success of her claims. And there are two specific sub-issues. Firstly, whether the claimant can satisfy the merits test on the basis of her pleadings. And secondly, whether she can satisfy the merits test on the evidence before the court. And these are related but distinct issues. In relation to both, the claimant seeks to rely on the presumption that foreign law is the same as English law to discharge the burden on the merits. And Mr. Justice Nichol and the majority of the Court of Appeal held that she was entitled to do so. We say they were wrong in law and that these claims are bound to fail in the absence of pleading of Egyptian law and to the extent that there is no evidence of Egyptian law. My lords, this ground of appeal raises important issues about the English court's approach to foreign law. The result of the Court of Appeal's judgment is to remove any requirement to plead foreign law, which represents a fundamental change to the established position in English law. Furthermore, in permitting the claimant to satisfy the merits test by relying on a mixture of the evidence of foreign law and the presumption, the Court of Appeal has adopted a novel approach, which we say is objectionable in principle and contrary to authority. More generally, the Court of Appeal's approach fails to recognise that the parties' rights and obligations are defined by the applicable law and cannot be assessed in abstract. These issues are of particular importance in the context of jurisdiction, as they impact on whether a foreign defendant can be brought before the English court. Our case is that the result of the Court of Appeal's judgment is to subvert the merits test and to reverse the burden of proof which the rules impose on the claimant, permitting the claimant to establish a sufficient case on the merits by relying on English law, whether by way of a presumption or default rule, when it's accepted that English law does not govern the claim, is artificial and wrong. The Court of Appeal's approach will result in foreign defendants being brought before the English court when there's no basis to do so. My Lord, the claimant advances three claims: a claim for loss of dependency, a claim on behalf of her deceased husband's estate, and a claim for her own personal injury. My submissions will focus initially on the dependency claim. Our case is that the claimant's case for the loss of dependency is bound to fail in the absence of any pleading of Egyptian law. And in summary, the reasons for that are that, firstly, the applicable law is not English law. Secondly, the claimant has no claim under English law. The Fatal Accidents Act is the only basis for a claim for loss of dependency in English law, and that act does not apply in this case. And thirdly, the claimant cannot rely on Egyptian law as she has not pleaded it, and there is no claim advanced under Egyptian law. The long-established position of the English court is that the foreign law is a matter of fact and needs to be pleaded and proved. And we say that the presumption does not assist the claimant. So for these reasons, the claim as pleaded is bound to fail. And we take a separate point on the lack of evidence of Egyptian law, that there's no claim in contract or direct liability in tort in the evidence before the court, but I'll deal with that after the pleading. In terms of the structure of my submissions, I'll address the court in four parts. Firstly, looking at the key elements of the legal framework. Secondly, the claimant's pleaded case. Thirdly, the claim under English law. And fourthly, the law on foreign law and the presumption. But just before I start on those four parts, I do invite the court to look briefly at one point in the judgment of the Supreme Court in the claim against Four Seasons Holdings, Inc. That judgment is found at EF 1772, and the part I would like to take your lordships to is on page EF 1782. As the court knows, the Supreme Court held that the claim against FSHI had no reasonable prospect of success on the facts. That's dealt with in the judgment of Lord Sumption at paragraph 15. But in addition, unanimously, albeit obiter, the Supreme Court held that the order for permission to serve out could not stand in relation to the loss of dependency claim, which was pleaded by reference to English law under the Fatal Accidents Act. And your lordships will see that Lord Sumption dealt with that in his judgment at paragraph 17 and 18 on page 1782. Lord Sumption says, if there had been sufficient reason for treating holdings as the owner or operator, I would in any event have held that the order for service out could not stand so far as it concerned the claims in tort. In the case of the claim for bereavement and loss of dependency under the Fatal Accidents Act, the reason is that the Act operates as part of the proper law of the tort and has no application to a tort which is not governed by English law. And my Lord, Lady Hale, at paragraph 33, EF 1790, agrees with Lord Sumption on that point. It's little 2 of paragraph 33. For what it's worth, I agree, little 2, that the action in tort is governed by Egyptian law, and so the Fatal Accidents Act cannot apply to it, although Egyptian law may in fact allow for a similar claim, should permission ever be given to plead it. Yes, my Lord, Lord Legate has a question.
Yes, Ms. Kemper, why should there be any difference between statute and common law in this respect? I mean, everybody agrees that English law does not apply. The Egyptian law is applicable. So either you take all English law and apply that by default, or you take none of it. There's no relevant differences there between the Fatal Accident Act and any other rule of English law.
Well, my lord, we would say that in respect of any of the claims, whether they're statutory or common law, the position is the same, that if there is no claim under English law and the only claim arises under foreign law, then a claim pleaded without reference to foreign law will fail. But the authorities show that the operation of the presumption in the context of statutes has been particularly problematic because statutes have or can have expressed territorial restrictions, for example. And in the Supreme Court decision in Cox, which I will take the Lordships to, the court did hold that the Fatal Accident Act has no extraterritorial application. But I agree with your Lordship that there's no difference in principle between statutes and common law in that sense. Does that answer your Lordship's question?
Well, I think the last sentence does, yes.
I'm glad I got there in the end, my lord. As I will show the court, the decision on this point, I should have said that both Lord Wilson and Lord Clark agreed with Lady Hale to the extent that she agreed with Lord Sumption. So it is a unanimous decision on this point. And as I will show the court, or endeavour to do so, this is in substance the same point as is now before the court in relation to the dependency claim. In the claim against FSHI only took the point on the merits on the dependency claim, but in this case the appellant takes the point on all three claims, but I am proposing to deal with the dependency claim first. I should also say that in the Supreme Court on the previous occasion we did make submissions on the presumption, both orally and in writing, and although not dealt with expressly in the judgment, if the Supreme Court had concluded that the claimant could rely on the presumption that in Egyptian law was the same as English law, the Supreme Court in my submission would not have ruled as they did. So, my lords, passing to the first part of my four-part submissions, the legal framework, two important elements of the legal framework. First of all, the merits test. We set this out in our written case from paragraphs 107 and following, and we look at the test and the history and purpose of the test, and I'm not going to go into that in detail, but I do say it's not a high threshold, but there is a minimum requirement for success, and the burden is squarely on the claimant. The focus is very much, the focus of the court's attention should be on the claimant's case, not on whether the defendant has proved that there is no case. The purpose of the merits test is that a foreign defendant should not be brought to the English court to answer a claim which has no reasonable prospect of success. And we say that in order for that to function properly, the assessment must be carried out on a realistic and true basis. The Supreme Court in Brownlie against FSHI considered that the minimum standard had not been met with respect to the dependency claim. The court concluded that there was no viable pleaded claim, and so even if FSHI had proved to be the correct defendant, the loss of dependency claim would not have succeeded at that point. The second fundamental part of the legal framework is the applicable law. It's common ground, my lords, that Rome I and Rome II determine the applicable law in this case, and that as a result of those regulations, Egyptian law applies to both claims in contract and in tort. And we summarise the position on that in our written case, paragraphs 116 to 120. It is worth noting that in respect of the tort claims, Egyptian law applies pursuant to Article 4.1 of Rome II. Article 4.1 provides that the law applicable is the law of the place in which the damage occurs. And in the context of claims arising out of a fatal accident, the Court of Justice held in Lazar, which is at EF 3140 of the bundle, that the damage for the purposes of Article 4.1 is the physical injury suffered by the deceased at the time of the accident. Is that physical bodily injury, the interference with the claimant or the injured party's interest, which determines the applicable law of all the claims arising out of that injury. So whether the claims are brought as person injury claims, either by the person injured, or as in, for example, in French law, ricochet type claims brought by other people because of that person injury, or in the case of a fatal accident, claims brought, loss of dependency claims, or claims under, for example, our 1934 Act. All of those claims arise out of that same damage, which is the bodily injury sustained at the time of the accident. And the European Court, the Court of Justice in Lazar, held that that fixes the applicable law for all claims arising out of such an accident. So in this case, it's Egyptian law. My Lords, for your note, the relevant paragraph of Lazar is 25. I wasn't going to take your Lordships to that judgment. My Lord, just to look at the claim which is advanced by the claimant against the defendant, I would like to take your Lordships to the original particulars of claim against FSHI. They're at EF 315. Paragraphs 2 and 3 set out the three different claims. So 2, the claimant brings these proceedings on her own behalf in respect of injury loss expenses. 3, the claimant was the wife of the deceased and is the executrix of the estate. She brings these proceedings on behalf of the estate under the 1934 Act and for her benefit as wife and dependent under the Fatal Accidents Act. So that's paragraphs 2 and 3. And paragraph 6, your Lordships will see, is the pleading of the claim in contract and tort. States that a contract was entered into. Further or alternatively, the claimant and deceased owed a duty of care at common law, and the said duty of care required the exercise of reasonable care and skill. And then, my Lord, if we can pick it up at paragraph 31, which is EF 321, paragraphs 31 and 32 set out the case on contract, subject to an implied term, and the said term is to be implied as necessary in the context of a consumer contract. Then 32, the basis of the claim based on being a principal to the contract or an agent, and 33, caused by negligence and or breach of contract. So very much pleaded by reference to English law. And your Lordships will see at 325, EF 325, paragraph 40, or just after paragraph 40, the prayer. The claimant claims damages on her own behalf, 1934 Act and the Fatal Accidents Act. So that's the claim. And that was the pleading before the Supreme Court in the claim against FSHI. By the time of that ruling, the claimant had accepted that English law was not applicable. By that time, the European Court had ruled in Lazar that the applicable law was the law of the place of the accident, effectively, and the claimant accepted that, but she argued that she could rely on the presumption that Egyptian law was the same as English law to establish the prospects of success of her dependency claim. The Supreme Court ruled over to her that that was not so, and there were no prospects of success. My Lord, following the Supreme Court's judgment, a witness statement was filed by Mr. Donovan on behalf of the claimant in support of an application for permission to serve proceedings against the current appellant, the Egyptian company. My Lord, you will find that at EF 396. I think it starts at 395. Mr. Donovan's fifth witness statement, and I just want to draw your Lordship's attention to a couple of paragraphs. Page 396, paragraph 2. This witness statement is served in support of the various applications, which include application for permission to serve the claim form as now amended, and to delete all references to rights arising under and by virtue of English statutes. This became necessary as a consequence of the ruling of the Supreme Court in Cox. And then Mr. Donovan says the LLC required the entire process to be recommenced, including the need for the claimant to seek a fresh permission to serve the claim form on LLC out of the jurisdiction. Well, my lord, clearly permission would be required against a different company. It was an Egyptian company who was being sought to be brought into the jurisdiction instead of FSHI, which had been a Canadian company, and so that process did need to be started. My lord, the claimant refers in her written case to the fact that we did not take out a Part 11 application in response. That's quite correct, but we were unable to do so because we were never served with an order which had been obtained by the claimant for permission to serve out. Your lordships may have noted in Mr. Justice Stewart's order that the claimant undertook to obtain such an order and serve it on it, but it didn't happen, and so we couldn't take out a Part 11 application. My lord, the only other paragraph I was going to take your lordships to was paragraph 42, which is at 411. 42, Mr. Donovan says, the other amendments that are sought by the claimant are those which flow inevitably from the ruling of the Supreme Court that the only claims which the claimant can advance in these proceedings are those which are available to her under Egyptian law by reason of the wrongful infliction of personal injuries upon her and the wrongfully caused death of her husband. And so that's the basis on which the particulars of claim was then repleaded. The amended particulars of claim is at EF 334, I apologise, 334. And my lords will see that paragraph 2 is in the same terms. Paragraph 3 deletes the references to the two English acts. Paragraph 6 deletes the reference to the common law. And paragraphs 31 to 33, which we looked at the equivalent before on EF 341, they remain in the same terms, so the contract and negligence claim remain in the same terms. But the prayer is amended. The prayer is at EF 345, and your lordships will see that the acts are deleted, and what is put in place is pursuant to Egyptian law. So that's the sum total of the amendments to the particulars of claim. But there is no pleading of Egyptian law. My lords, the Court of Appeal ordered the claimant to plead Egyptian law. The Court of Appeal's order is at 159. .159 is the order. On page 160, the relevant paragraph is 6A. Following the final determination of the appellant's appeal, the respondent shall apply for a hearing, A, for permission to rely upon proposed re-amended particulars of claim, pleading the content of Egyptian law, including the relevant principles and sources on which she relies and on which each of her claims are based. So that's an order to plead the content of Egyptian law. It's not an order for further and better particulars. My lords, as you will know, the claimant appeals the Court of Appeal's order. The claimant's case is that the pleading of English law is sufficient, and she seeks to rely again on the presumption that foreign law is the same as English law to discharge the burden of establishing that her claim has reasonable prospects of success. The claimant's permission application, which is at EF 36, makes that quite clear. Paragraphs 24, 26 and 27. I wasn't going to take your lordships to that, but it's quite clear that's the claimant's case, that she does not need to plead her case under Egyptian law. My lords, moving then to the third part of my framework, this is to look at the claim under English law. So looking just at the loss of dependency claim for now. The Fatal Accidents Act is the only basis for a claim for loss of dependency in English law. There is no claim at common law. My lords, that was the Supreme Court considered the Fatal Accidents Act in the case of Cox and Ergo, which your lordships will find at EF 1934. The question arose in this case as to whether the Fatal Accidents Act had extraterritorial effect, whether it applied to a fatal accident abroad. The claim arose out of a road traffic accident in Germany. The husband of the claimant had been killed, and the claim was brought under the Fatal Accidents Act and in the alternative under provisions of German law. But the Fatal Accidents Act, English law, was more favourable to the claimant, so the claimant wanted to rely on the Fatal Accidents Act. The Supreme Court held that the claimant could not rely on the Fatal Accidents Act. My Lords, if page EF 1935 is the second part of the head note, and paragraph 3 summarises the effect of the decision, that as a matter of construction, there was nothing in the mischief or the language of the Act to suggest that its provisions were intended to apply to foreign fatal accidents with no connection to England or English law, and irrespective of the choice of law derived from the principles of private international law. And my Lords, if you turn into the judgment of Lord Sumption, who gave the leading judgment, starts at 1940, EF 1940. Just want to draw your Lordship's attention to the first sentence on page 1942, where Lord Sumption states the position clearly: these statutory provisions remain the sole legal basis on which a claim can be made for bereavement or loss of dependency in English law. And then 1952, paragraph 34, Lord Sumption says, thirdly, there's no reason whatsoever why Parliament should have intended the Fatal Accidents Act to apply to foreign fatal accidents with no connection to England or English law. Neither the terms nor the purpose of the Act depend for their effect on its having extraterritorial effect. And then 1955, just picking up at the end of the judgment of Lord Mance, who agrees with Lord Sumption's reasoning and conclusions on those points. And so as a result of Cox, it was clear as a matter of English law that the Fatal Accidents Act had no extraterritorial application. It did not apply to a claim arising from an accident abroad where the law applicable was not English law. And in Brownlie against FSHI, which we looked at briefly, the Supreme Court held that as a result of Cox, the claimant's claim for loss of dependency had no prospect of success, and no other claim was pleaded. The position is no different in this case. The Fatal Accidents Act has no application. The applicable law is accepted not to be English law, and the Act has no extraterritorial effect. And so we say that under English law, it has no prospect of success. Yes, my Lord, Lord Legate?
You won't be surprised I'm raising the same point, Ms. Kinsley, because I thought you'd accepted there was no relevant difference between statute and common law. I mean, everybody agrees that English law is not applicable, is not the applicable law in this case. So what good does it do to point out that a particular provision of English law doesn't apply to the claim? The question is whether we treat Egyptian law as like English law for this purpose or whether we don't.
Well, my Lord, as I said, I do agree that as a matter of principle, there is no difference, but the authorities, which I will take the Lordships to, do consider that in the cases of acts and statutes, the operation of the presumption is particularly problematic, and particularly when the statute has been held not to have extraterritorial effect. But I agree, in our case is that there is no difference, and as soon as the applicable law is not English law, then in the absence of any pleading of a claim under foreign law, that claim will fail. But the Supreme Court held obiter in Brownlie FSHI that a claim based on the Fatal Accidents Act would fail. And although there's no reference to the presumption or default within the judgment, that was the argument before the court. The written cases show that that issue was before the court. I made these submissions on that occasion, and we dealt with the cases that I'm going to take the Lordships to. So we say the position is clear on the Fatal Accidents Act. My Lord, moving on to the fourth part of my submissions, looking at the, yes, my Lord, Lord Briggs.
Just before you do, Ms. Kinsler, let's step into what you will no doubt try and persuade us is the make-believe world presumption can apply in a situation of this. In Egypt, if Egyptian law is presumed to be the same as English law, does it mean that Egypt is assumed to have a codal or other statutory provision enabling dependency claims to be made that the accident occurs in Egypt, or only where the accident occurs in England?
Well, my Lord makes a very good point, and we say that the court has to be very careful about the operation of the presumption, and that effectively the court can only apply either English law or Egyptian law. It can't apply either a mix or a hybrid in between. So if you presume that foreign law is the same as English law, then Egyptian law would have that territorial restriction in it.
Yes, but I'm asking you which territorial restriction. Would it be that would the presumption, if it works at all, mean that Egyptian law would simply apply, permit dependency claims in relation to accidents occurring in Egypt, or, as I would have thought completely bizarrely, only in relation to accidents occurring in England?
Well, my Lord, we would say that if English law has a territorial restriction in it that it applies to accidents in England, then if by operation of the presumption, if you're presuming the foreign law is the same as English law, it would have that same territorial restriction. But in a sense, if the court thinks about it in terms of the default rule, which is the other way of looking at the presumption, I think it becomes the focus is perhaps a bit sharper, because the way that would operate is to say that in the absence of evidence of foreign law, the court in fact applies English law. And if the court is in fact applying English law has this territorial restriction and doesn't apply. My Lord, I was going to take lordships to the authorities now, to a number of cases. We're also fortunate to have quite extensive commentary in this area. In the written case, we've referred on a number of occasions to the book by Richard Fentiman, Foreign Law in the English Courts, an extract of which we've included at EF 3408. And we say that the extract from Foreign Law in the English Courts is a lucid and, in our submission, helpful exposition of the concepts and practical issues in this area. My Lord, I was going to start by taking the court to Dicey, just to get some of the principles clear. Dicey is at E3364. And the extract is from chapter 9 of Dicey, entitled Proof of Foreign Law, and I was just going to highlight a few passages for your lordships. So Rule 25.1, in any case to which foreign law applies, that law must be pleaded and proved as a fact to the satisfaction of the judge by expert evidence or sometimes by certain other means. In the absence of satisfactory evidence of foreign law, the court will apply English law to such a case. Foreign law as a fact, the principle that in an English court foreign law as a fact has long been well established, and it must be pleaded and it must be proved. And then a few lines down, it's also said to follow that if the parties elect not to prove the content of foreign law, a case will be decided by the application of English domestic law as though the case were a wholly domestic one, and this is generally true. But in recent years, there have been increasing signs that this cannot invariably follow. And in cases where it would be wholly artificial to apply rules of English law to an issue governed by foreign law, a court may simply regard a party who has pleaded but who has failed to prove foreign law with sufficient specificity as will allow an English court simply to apply it as having failed to establish his case without regard to the corresponding principle of English domestic law. My Lord, I highlight for your lordships the first two sentences of 9003 and the first sentence and a half of 9004. And then if we could move to EF 3378, the section starting burden of proof. The burden of proving foreign law lies on the party who bases his claim or defence on it. If that party adduces no evidence or insufficient evidence of foreign law, the court applies English law. This principle is sometimes expressed in the form that foreign law is presumed to be the same as English law unless the contrary is proved. But this mode of expression has given rise to uneasiness in certain cases. In one case, the court refused to apply the presumption where the foreign law was not based on common law, and in others it's been doubted whether the court was entitled to presume that the foreign law was the same as a statute law of the forum. In view of these difficulties, it's best to abandon the terminology of presumption and simply to say that where foreign law is not proved, the court applies English law. Even so, there will still be cases in which the application of English law, whether because the party seeking to have foreign law applied has pleaded foreign law but has failed to prove its content, or because the parties have tacitly agreed not to seek to prove the content, will be just too strained or artificial to be appropriate. However, although recent authorities demonstrate that there are cases in which neither the presumption nor the default application will be suitable, they do not yet offer precise guidance as to when this point will be reached. And my lords, I draw your attention also to paragraph 9027, the part of 9027 on EF 3379. And that deals partly with the question of statutes and whether you can extract from a statute the gist of principles said to be generally applicable, and also 9029 on EF 3380. Apart from the fact that a court should not invent a rule of English law to be applied in default of foreign law, no sharp line exists to define the limits of the principle that in default of sufficient proof, foreign law will be taken to the same as English law. So that's dicey. Moving on then to the cases. My lords, I was going to take the cases in broadly chronological order, starting with the important case of Bumper Development Corporation, which is at 1857. And there's just some important points of principle dealt with in the judgment of the Court of Appeal. The issue before the Court of Appeal was whether a temple could sue for the recovery of a stolen bronze statue on the basis of Indian law. The temple did not have legal personality under English law, but it was held that the temple was entitled to sue. If we pick up the judgment at 1863, the Court of Appeal's judgment given by Lord Justice Purchase, and I just want to highlight 3 points of principle. Picking it up at letter E, the judge reviewed at length the evidence of Hindu law, not only as set out by textbook writers and in judgments, but also the oral evidence given before him, before reaching his conclusions as to which claimants would be acceptable as juristic entities in the courts of Tamil Nadu. However, before coming to consider the evidence on this aspect of this case, it's convenient to consider the position in the English courts. It is trite law that foreign law in our courts is treated as a question of fact, which must be proved in evidence. In the absence of any evidence to the contrary, it is to be assumed to be the same as English law. So that's the first important point. Turning over to 1865 and picking it up just above, or just at letter C, the Court of Appeal is looking, in fact, at the question as to when an appeal court can interfere with a trial judge's decision on foreign law. But in that context, the court refers to the well-known decision of Parkashu and Singh and the dicta of Mr. Justice Cairns giving the judgment. Picking it up 3 lines in, the question of foreign law being a question of fact in our courts, must this court regard itself as bound by the findings of the justices on this matter? In my view, the question of foreign law, although a question of fact, is a question of fact of a peculiar kind. And I do highlight that, my lord, because, yes, my lord, Lord Brigg, Lord Jones.
Into that passage, please.
I'm so sorry, I couldn't hear you.
Could you give us the reference again to that passage, please?
Certainly, it's 1865, EF 1865, and it starts just above, just at letter C.
Thank you.
So I highlight that, a question of fact of a peculiar kind, because obviously foreign law is a question of fact of a peculiar kind. The court, the English court, treats it as fact and requires it to be pleaded and proved by evidence. but foreign law is not the same as other facts because it defines the rights and obligations of the parties. And then just picking it up at the bottom of that page, referring again to the decision of the Divisional Court in Parcashu and being approved in the Court of Appeal in Dalmia, Lord Justice McGaw saying, but a finding of fact on an issue of foreign law is a finding of fact of a very different character from the normal issue of fact. We would adopt as correct the observations of Mr. Justice Kearns as he then was. And then page 1866, just over the page, the third point is the approach of the court to foreign law evidence. Just at little b, with these authorities in mind, we had come to the conclusion the judge was not entitled to reject the evidence of the experts to the effect that Sadagopan did not have a sufficient continuity of association to qualify as a de facto trustee. We've also come to the conclusion that Mr. Calcutt was correct in submitting that the judge was not entitled to rely upon his own researches without having the assistance of the expert witnesses. I think in that case, the judge had rejected both experts' testimony and come to his own view about Indian law based on his researches. The second judgment I would like to take your lordships to is the judgment of Mr. Justice Oliver Popwell in University of Glasgow and The Economist. It's at EF 2670. And this is a case which is regularly cited in relation to the presumption, but it is important to see what it actually says. It arose out of a libel claim by the University of Glasgow and Edinburgh against The Economist in respect of the publication of a book. And there's 2 points to note. First of all, the judgment is in the context of the common law rule on double actionability. And just a quick reminder about that rule, 2675 of the report, the judge cites the rule from Dicey and Morris on double actionability, so it's a convenient point to pick it up. Rule 205 is a general rule, an act done in a foreign country is a tort and actionable as such only if it is both actionable as a tort according to English law, or in other words, an act which if done in England would be a tort, and be actionable according to the law of the foreign country where it was done. It's not necessary that the tort would have been actionable as a tort abroad, but it did need to be civilly actionable. It needed to be actionable as a tort in England. But in the context of double actionability, the law on which the claimant relies to found their claim is English law. And so it's really a precondition to that claim arising is that there is civil actionability in the foreign law. But the basis of the claimant's claim is English law. And that's an important difference when we come to look at the 1995 Act and Rome II and the position of the foreign law under those acts. So under double actionability, the claim is based on English law and the role for foreign law is limited. The issue which this case addresses is the correct approach to pleading in the context of double actionability and whether the presumption can be relied on in that context. And your lordships will see from 2672, ahead, I've just lost my reference. But it was a controversial, yes, 2672. Your lordships will see about 10 lines down that it was a controversial issue. The question of whether that is a proper plea has apparently been the subject of differing views in the Master's Corridor and among the profession. And the judge holds that the claimant need only assert actionability under foreign law. And it's for the defendant to plead foreign law if he wants to contest the point. Your lordships will see that at paragraph 2 of the head note, which is on 2671. All the plaintiff had to do was to allege the tort was actionable in another country. He could, if he so wished, affirmatively set out the law in that foreign country to support that plea. If he chose to do so, he had to plead the facts and matters on which he relied. But the plaintiff did not have to set out what the law was. because unless and until the foreign law was shown by the defendant to be different, the court would presume that English law applied. And the judge dealt with that point at page EF 2677, the last paragraph, having looked at Dicey. All the plaintiff has to do is to say that the tort is actionable in another country. And I think then the next few lines is really just as it appears in the head note. But what's important to note about this is, one, that it is in the context of double actionability, so the claim is actually an English law claim. But secondly, the judge is quite clear that if the claimant does choose to set out affirmatively that a tort is actionable in another, by reference to the law of another country, he must plead the facts and matters on which he relies. My Lords, I was going to take your Lordships now to the case of Shaker and Al-Badrawi, which is at EF 2521.
Take it again, please.
2521.
Thank you.
The question in this case was whether the defendant could rely on the presumption in respect of the statutory requirement in the UK Companies Act that a company should have relevant accounts before making a distribution. And it arose in the context of the consideration of the prudential principle, the reflective loss principle, which I know your Lordships have had occasion to look at more generally recently. But the defendant had to establish the crucial question as to whether there was an unlawful distribution, and if it was, the company had a claim against Al-Badrawi, and pursuant to the prudential principle, the shareholder did not. No evidence was given of Pennsylvanian law. The judge held that the presumption could be relied on because the Companies Act reflected a general principle of corporate law, which would apply to the Pennsylvanian company despite the fact that it wasn't English. But the Court of Appeal allowed the appeal, and we could pick it up at 2526. Actually, 2542. 2542. And the judgment of the Court of Appeal, the judgment's given by Lord Justice Peter Gibson, and the court was Lady Justice Arden, as she then was, and Mr. Justice Buckley. And starting at paragraph 63, the court deals with the question between 63 and 68. And I was going to just highlight a few points for your Lordships. So 63, the judge applied the provisions of the 1985 Act. He held this was a generally applicable rule. Was the judge correct to apply English law, specifically these provisions? And then 64, according to Dicey and Morris, where a party adduces no evidence, the court applies English law. And there's only one true exception to this principle. That was obviously Dicey and Morris at the time. In the opinion of Dicey and Morris, it's not clear that there is a further exception where the question is purely one of statute law. However, it is apparent there are other exceptions apart from those which Dicey and Morris cite. So the court then, in that paragraph, looks at other instances of exceptions to the presumption rule. Picking it up then at 67, the court says the starting point must be that not every English statute is to be applied to a transaction because a party has either chosen not to prove or failed to prove the law which is otherwise applicable. So that's the starting point. And then just looking at the paragraph, just continuing in that paragraph, just over the page, the court notes that Mr. Lyndon Stanford has made his submissions on the basis that this requirement has to be met. I think the requirement is that it is a rule of general application. We're content to accept that is so in the circumstances of this case. However, a rule of English statute law has to be adapted in the way explained above before it can apply. although it's not necessary to express a final view on this point on this appeal, it may well be that that factor alone is a sufficient indication that the case falls within the class of case where English statute law creates some special institution and thus cannot be applied simply because a party has failed to prove the relevant law. So that's the court looking at the question in the context of statutes and effectively saying that you can't adapt a statute, so you can't adapt an English statute to apply to a foreign law through the prism of the presumption or the default rule. Just continuing at 68, we dealt with the question whether it is realistic to expect a foreign law to contain a provision found in English law as a relevant consideration in deciding whether to apply English law as a lex causa in default of proof of foreign law. So again, the court making an important point that whether in the court's view there is likely to be an equivalent principle in the foreign law is not relevant to whether the presumption should apply. And just, I skipped over paragraph 66, but I should just draw your lordship's attention to it before we move on. The court in 66 starts the paragraph saying the 1985 Act cannot be applied literally to the Pennsylvanian company, since it only applies to English companies. Mr. Lyndon Stanford, little e, accepts that the Act can only apply in an adapted form. But what if, for instance, Pennsylvania law has no such requirement? How is English law then to be applied? Mr. Lyndon Stanford's submissions leave that point unresolved, and it is an Achilles heel in his argument. We find it difficult to accept that if English law is to be applied, it can be applied in a form adapted to the degree necessary. Either it applies to a Pennsylvanian company or it does not so apply. And my lords, I come back to my submission that the court has to be careful in the operation of the presumption. Either the court's applying English law or the court's applying foreign law, but it's not possible to adapt English law through the presumption to look like English law but be different. So in relation to the statute, if it does have a territorial restriction in it, it's not possible to adapt that to find an equivalent statute under Egyptian law with a different territorial restriction. My lords, I was going to take lordships to the case of Global Multimedia, which is at EF 2090. It's a judgment of Sir Andrew Moore, the Chancellor, in the case of Global Multimedia. It was an application by a Part 20 defendant to set aside a permission to serve out. The Part 20 claim was a claim by AMS against its employees. That's clear from paragraph 10 of the judgment, which is at EF 2094, and the judge notes that duties of fidelity and good faith are pleaded in conventional terms. My lord, we can pick it up, I think, at 37 in the judgment. So the judge has concluded that the Part 20 defendant had submitted to the jurisdiction and concluded that England is the forum conveniens, but he then goes on to look at the third issue, which is dealt with at 37. He says, in these circumstances, the third issue to which I have referred does not arise, so it's unnecessary to deal with the submissions, and with one exception, I shall not do so. The exception relates to the pleading of the Part 20 claim, specifically a complete absence of any reference to Sharia or Saudi law. Counsel for AMS sought to justify this by reference to Dicey, and the paragraph that we looked at, it's the same, in exactly the same terms as it now is in the 15th edition. The quote and the quote just after the both quotes are currently the same in Dicey. And then picking it up at 38, counsel for AMS stressed the word "if" in the first passage to which I have referred, he suggested that it was sufficient in the first instance to rely on the so-called presumption referred to in the second passage and leave it to the defendant to ascertain and rely on any aspect of foreign law he considered to be different and material. If the defendant did so, then the claimant would have to deal with the issue in his reply. And he referred to Monetary Fund and Hashim. The Chancellor says on 2106, this submission does not reflect my experience either at the bar or on the bench. And he refers to the old system of pleading where it was necessary to plead foreign law. That requirement arose from the terms of RSC Order 18, because in the absence of such pleading, foreign law was a matter which might take the opposite party by surprise. The CPR do not contain any similar express requirement, but it would be inconsistent with provisions of CPR 16.4 and the overriding objective deliberately to omit an allegation of some material fact, namely relevant principles of foreign law. As the passage I've quoted from Dicey points out, it's inaccurate to refer to a presumption that foreign law is the same as English law. The true proposition, I believe, is that as foreign law is in most cases a question of fact, to be proved by evidence, in the absence of such evidence, the court has no option but to apply English law. But if the facts alleged demonstrate that, for example, the proper law of a contract is not the law of England, then as the law of England includes the principles of private international law, those principles may demonstrate that some other system of law is applicable to the claim. And if the relevant principles of that system of law are not sufficiently proved, the claim may fail for that reason. And then 39, the Part 20 claim is a good example. He refers to the claim and that the obligations of fidelity were implied by law. Given the allegations in relation to the parties to and formation of the employment contracts, the law there referred to must be the law of Saudi Arabia. Yet there is no attempt to say what it is, or in the sense of legal source where it is to be found. In my view, such pleading is deficient. It's not a mere pleading point, but one of justice. If, as in this case, the true claim is based on propositions of foreign law, then the party who advances it should make it good by reference to the system of law on which he relies. And so the Chancellor is making 2 points. Yes, there is a pleading point. It's inconsistent with the requirements of CPR, the CPR rules to plead material facts, which include foreign law. And you need to plead the content, what the law is, and the legal source, the relevant provision. If not, the pleading is deficient. But it is more than just a pleading point. And in my submission, if the true claim is based on foreign law and can only be based on foreign law, a party who advances it must make it good by reference to that system of law. And the consequences of failing to plead such a claim is that there is no claim. My Lords, judgment of Mr. Justice Cook in Tamil Nadu next, which is at tab EF 2634. This was a dispute arising from a power purchase agreement between the claimant and defendant for the supply of energy in India. It contained an arbitration agreement in favour of London. London ceased an express choice of law for England of the arbitration agreement, but the agreement itself was governed by an express choice of Indian law, which your Lordships will see from paragraph 10. Paragraph 10, the PPA expressly governed by the law of India, while the arbitration agreements expressly governed by the law of England. One of the issues will require the examination of Indian law. Your Lordships will see that from paragraph 15. And expert evidence of Indian law was adduced by both parties. That's clear from paragraph 52, which is on 2650. Start of 52, each of the experts called by the parties was a distinguished Indian lawyer. If we could pick it up at paragraph 97, which is 2661. The judge said, I should at this point mention the ruling I made on the 5th of July. TNEB sought to raise fresh issues of Indian law in relation to the Indian General Clauses Act, or alternatively to rely on the English Interpretation Act. Reliance on the latter was to be based upon the presumption that absent evidence to the contrary, Indian law is to be treated the same as English law. For case management reasons, I refused DNEB's application to adduce fresh evidence or to raise a new point of Indian law, upon which neither expert has expressed any view. And then 98, equally, I can see no basis for allowing TNEB to rely on any presumption as the equivalence of Indian law with English law. The artificiality of such a presumption when the parties have been permitted and have produced expert evidence of Indian law is obvious. And then 99, the judge continues looking at the specific matter in that case. That was an agreed list of issues. The whole purpose of the list of the issues and the order for expert evidence was for the parties to set out and prove their cases on Indian law. Be wrong to subvert that by allowing reliance on the presumption of similarity, and reference then to Rich Fentiman's book, and the following propositions can, in my judgment, be garnered from there. As Justice Cook says, there's no adequate support in the decided authorities for the principle that English law should govern by default where foreign law is relied on by a party who declines or is unable to prove it. Secondly, it would be wrong to allow the presumption to be used by a party where he pleads or wishes to rely on foreign law but declines to prove it. That would reward a person who alleges foreign law without proving it. The presumption is aimed at the situation where foreign law is neither pleaded nor proved, and the parties in the court are to be taken as content to proceed on the basis of the presumption, since no one has sought to establish there is any relevant difference. And 3, if the failure to prove foreign law by a party is the result of a tactical decision after seeking to rely on it, reliance by that party may amount to an abuse of process. And then just picking it up at the end of 101, the last sentence, it's not a pure question of English law. It's a presumption which the court could not properly accept in a situation where foreign law evidence has been admitted on the specific issues requested by the parties. So the key points I take from this judgment are that the presumption should not operate in circumstances where it's artificial to do so. So if the court knows that foreign law is different, the presumption cannot operate on the ordinary terms. So it operates in the absence of evidence to the contrary. But if the court knows, as the court does in this case, that foreign law is different, it is not appropriate for the presumption to operate. Whereas this was the only case that we could find where a party has adduced evidence, also seeks to rely on the presumption, adduced evidence of foreign law. My Lords, I was going to then take your Lordships to the important judgment in Belhaj, both the first instance and Court of Appeal judgment. They are the first instance judgments at E1650, EF1650. And this was the rendition case. My Lords, paragraph 119 of the judgment of Mr. Justice Simon sets out the issues. It's EF 1677. Mr. Justice Simon, 2 issues arise on this part of the preliminary issue. First, whether the applicable law is the law of those other countries or whether it's English law, and that depends on the 1995 Act. Secondly, if the applicable law is the former, so foreign law, whether the court should apply English law in the absence of pleading and proof that the law of those states is different. And then picking it up at 123, further down the page, it follows that on the claimant's pleaded case, there are 3 possibilities. A, foreign law supplies a remedy by some undefined mechanism. B, English law applies by reason of section 12 of the 1995 Act, so the displacement provision under the 1995 Act. Or C, if a foreign law applies, the defendant should plead it. In the course of argument, Mr. Hermer adopted a less evasive and rather more realistic approach, conceding that it was unlikely that the laws of England and Wales applied to the claimant's alleged detention in China or Malaysia, and that the real issue was not so much which law or laws applied to the alleged torts, but which side should plead the applicable law first. This requires consideration of the 1995 Act. And then turning to EF 1680, picking it up at paragraph 136. Mr. Justice Simon states, in summary, Mr. Harmer, for the claimant, argued that the issue of the applicable law was fact sensitive and that the pleading should await findings of fact as to what occurred. He developed this by a number of further submissions, and it's only the third submission we need to pick up. Thirdly, he argued, in the meantime, the case should proceed on the basis of the presumption that foreign law was the same as English law. And then turning over to 1681, paragraph 139. As to the third point, Mr. Harmer submitted that absent any reliance by either party on foreign law, the court should apply English law. He drew attention to the observations of Mr. Justice Gray and Al-Misnad. I further accept that it was held in the University of Glasgow that at least at the pleading stage, a claimant is entitled to rely on the presumption that foreign laws are the same as English law. And we looked at the University of Glasgow, my lord, and it is in the context of double actionability. Mr. Justice Gray noted that the Supreme Court's Procedure Committee on Practice and Procedure in Defamation described the presumption as quite unrealistic and curiously egocentric in the post-imperial age. And then in 140, Mr. Justice Simon sets out his his judgment on the position with respect to the presumption. Little a, he says, although it's open to criticism and subject to exceptions, a court of first instance cannot ignore the rule that in the absence of evidence, foreign law is presumed to be the same as English law. He so acknowledges the existence of the presumption, but notes the exceptions as well as the criticism. Little b, on the other hand, I consider that the decision in the University of Glasgow is of doubtful continuing authority. The case was decided in 1990 under the old pleading rules. I'm doubtful whether the practice of libel pleading should be applied more widely, not least because the double actionability rule still applies to defamation proceedings. He's entirely correct, I think, to be doubtful about the authority on the issue of the presumption generally, given the specific context of double actionability. As I said earlier, the point about choice of law framework is crucial. The role of foreign law is different under the three different choice of law rules that we've had in the English courts over the recent times. The double actionability role for foreign law is very limited. It's simply a precondition to the claimants being able to bring the claim based on English law. Under the 1995 Act and Rome II, the law applicable to the claim is the law determined by those rules. That's the legal basis for the claim. And so it's a very different position because that law in fact governs liability and heads of loss. It defines what someone is liable for. Yes, my lord, Lord Reid.
It's Lord Burrows.
Oh, I'm so sorry, Lord Burrows.
Yes, in a lot of the passages we're being referred to, no distinction is being drawn, I think, between pleading and evidence, or at least I should say they are both being looked at together. And I just want to be absolutely clear, what is your complaint? Is it purely as regards pleading, or is it also as regards evidence?
So, my lord, we have two separate points that we make. So firstly, as regards pleading, we say that because foreign law is a matter of fact which has to be pleaded, then in the absence of proper plea of foreign law, there is no claim on the pleadings. The pleading is not viable because if it only pleads English law and English law does not apply, there is no claim. And we say that's the effect of the obiter decision of the Supreme Court in FSHI, that in that case, the pleading was only on the basis of the Fatal Accidents Act. The court held that that claim was bound to fail. And the result was that the loss of dependency claim had no reasonable prospects of success and was bound to fail. We say that's because there was no pleading of foreign law. And then on the evidence point, we say there's a separate point that arises there. Even if a claim is proved in evidence, the court can be satisfied that the claim has reasonable prospects of success, but it does need to be proved in evidence. So in this case, for example, we say there is no evidence before the court that there is a claiming contract under Egyptian law. And as a result of that, that claim will fail. So the starting point is the pleaded case, because that's the case that's advanced against the defendant, and that's the case on which permission is sought and granted. That's the basis of the case, and we say in the absence of pleading of foreign law, there is no claim if it's not an English law claim. But separately, we say that there is a point with regards to proof of foreign law. If the evidence before the court does not show that there is a claim in foreign law, the claim has no prospect of success. It's possible, as the Court of Appeal, I'm so sorry, my lord.
No, please finish.
I was just going to say it's possible that as the Court of Appeal, Lord Justice Arnold held that there was evidence that there was a claim in vicarious liability and tort, and indeed we have accepted that on the evidence there is reasonable prospects of that claim. And Lord Justice Arnold ordered that would have ordered that the permission application was conditional upon the pleading of that claim to make it a good claim. But the claimant has indicated very clearly that she does not want to amend her claim. She appeals the order of the Court of Appeal to plead her claim by reference to foreign law, and we say that on her pleading the claim will fail. Does that answer your lordship's question?
Yes, it does. Thank you. But can I just then follow up? I mean, you're not suggesting, are you, that the Supreme Court in what I'll call Brownlie 1 has already decided this issue as regards pleading? Because as I understood it, Lord Sumption was saying, as the pleading then stood, and of course we've had, whether you think it's enough or are arguing it's not enough, but clearly we're not in the same ballpark. We've got an amended pleading.
No, that's absolutely correct, my lord. And we see he was deciding the point only on the pleading point. So there was no evidence of Egyptian law at all before the court at that stage. So the point that was being argued and the point that the court was focused on was whether there was a viable pleaded claim. So quite separate from whether there was any evidence. There was no evidence of Egyptian law at that stage. There was footnotes in various written cases about Egyptian law, but there was no evidence. So the point that the Supreme Court was deciding was the pleading point. But the decision, the Obiter decision, was taken on the basis of the original pleaded claim, which was referring to and relying upon the English Act of Parliament, the Fatal Accidents Act. So it was that pleading that was being considered. Our case is that the pleading has now struck through the references to those acts quite properly, but has added nothing back in. So it hasn't added in a plea under foreign law. Lord Briggs.
All the heads of claim that are made in the prayer are said to be under Egyptian law. So as a matter of bare formality, as I read it, is now a claim made under Egyptian law and in the dependency context expressly not made under the Fatal Accident Act, which is the situation that prevailed before the Supreme Court last time this case was before us. But so as a matter of bare pleading, without any particulars, why is it not a claim that the facts which we set out give us an entitlement to relief as per our prayer under Egyptian law?
My lord, is quite correct to say that the prayer says it's under Egyptian law, but we say, and I think the Court of Appeal accepted that and I think the authorities show that pleading foreign law means pleading the content of foreign law, so pleading the claim that you have under foreign law, both the content of it, what the principles are, and what the source of your obligations are. That is that's the facts that you need to plead. Because English law treats foreign law as fact, those need to be set out in order for you to have a cause of action. So we know from the evidence before the court that the Egyptian law system is quite different from English law. It's a code-based system. Each code gives rise to separate obligations with different requirements. So, for example, there is evidence of a strict liability contract claim under the Commercial Code. That's not a claim where you would plead a duty to breach, or implied duty to take reasonable care. It's a strict liability claim. It's based on a specific act. Different facts need to be established. So we say to plead foreign law, the authorities demonstrate that you need to plead the content and the source. And the Court of Appeal's order directs the claimant to plead the content and source. Yes, my Lord, Lord Jones.
Ms. Kinsler, is there not a difference? Ms. Kinsler, is there not a difference between asserting that foreign law governs a particular issue and asserting the content of the foreign law?
There is certainly a difference. We say to establish a viable pleaded claim, a party needs to plead the content of the foreign law and the sources of the foreign law, certainly the content, because in circumstances where the foreign law is quite different from English law, unless the content is pleaded, what the obligation is, what it is, what the nature of it is it strict or fault-based, who it is imposed on, what it makes that party liable for, unless that is pleaded, and those matters are all matters of fact in the English court, the defendant does not know what claim is advanced against it.
Well, in that case, is anything left of the default rule?
Well, my Lord, our submission is there is scope still for the default rule or the presumption to apply, but not in a case where a party relies on foreign law. So in this case, the claimant accepts that she can only bring her claim under foreign law, under Egyptian law. She has no claim under English law. And we say in those circumstances, it could not be right for the presumption somehow to operate to effectively allow the claimant to rely on English law. If there is no English law claim, the idea that we could nod to foreign law by saying this claim is brought under Egyptian law, because the choice of law rules require that, but actually we're going to apply English law, is nonsensical.
But strictly, she's not relying on English law. She's relying on foreign law, which is assumed to be the same as English law.
That's right. She's bringing her claim on the basis of foreign law. She acknowledges she needs to do that. But because she hasn't pleaded her claim under foreign law, she says she is entitled to rely on English law. But in our submission, that simply circumvents the choice of law rules. The choice of law rules direct the court to apply foreign law. Does that answer your Lordship's question?
Well, if that position is taken by a claimant, it's open then to a defendant to say that the content of foreign law is not the same as English law.
It is, absolutely.
So the matter doesn't go by default in those circumstances.
It
only go by default if both parties agree that it should.
That's correct, my Lord. But the presumption of the default rule in our submission needs to be looked at, particularly in context. So if the claim only can arise under foreign law, and that's partly why I took your Lordships to the Fatal Accidents Act, because that is slightly different in this context from the common law in my submission. The presumption also needs to be looked at the particular context of the position that the parties have adopted, and also the procedural context. So the procedural context before your Lordship is an application for permission to serve out of the jurisdiction. The burden is squarely on the claimant to establish for the court that she has reasonable prospects of success. The claimant sought to do that in front of the Supreme Court against FSHI by relying on the Fatal Accidents Act, and in argument, relying on the fact that even if the Fatal Accidents Act did not apply, she could rely on the presumption that Egyptian law was the same as foreign law. The Supreme Court unanimously said the claim as pleaded under the Fatal Accidents Act has no prospects of success, will fail, and that no claim has been pleaded under Egyptian law. And our position is that there still is no claim pleaded under Egyptian law.
Well, at the moment, I have difficulty in understanding why the fact that this issue arises in the context of an application to serve out, and there's a burden on the claimant to meet the merits test, makes it different from any other case in which there's a burden on a claimant.
Well, we would say that whenever the burden is on the claimant, if the only claim that is available is under foreign law, then the claimant is under an obligation to satisfy the court by reference to that foreign law, the claimant itself, and whether it's a jurisdiction application or an ordinary claim, if there is no claim available under English law. And that's why the position on applicable law is critical. So if there's an issue about applicable law, the position would be quite different. But once there is no issue about the applicable law, so if it was arguable that English law applied, then the question about whether the claimant could rely on the presumption would be different in my submission. But in circumstances where it is not arguable, it was not arguable in the Supreme Court, and it is now accepted that the applicable law is Egyptian law, in those circumstances, the position is different because there is no claim available under English law. The claimant only has a claim based on foreign law. And the English court to date has, or until the Court of Appeal certainly, has required claimants who rely on foreign law, who bring their claim on the basis of foreign law. The English court has required claimants to plead that claim to be viable. And that's our submission on that point.
Thank you.
Lord Leggett.
It does seem to me, Ms. Kinzer, that the logic of your argument is that there is no presumption.
Yeah.
I mean, you may be right about that, but that seems to be the logic. As I've understood it, the only scope you give for it is in a situation where a claimant is asserting that English law applies. But if the claimant is asserting that English law applies, they don't need the presumption. And it can't be the case, can it, that where they're asserting that English law applies but have an alternative claim, that if they're wrong about that, it's Egyptian law, then in that case they can rely on the presumption, but they can't if they're just claiming that it's Egyptian law. I mean, it's either there is a presumption for foreign law or there isn't.
Well, my lord, I do say that whether by route of the presumption or whether by agreement under both Rome 1 and Rome 2 permit the parties to agree a different choice of law, and it may be that those provisions under the regulations do a lot of the work that the presumption does, because the parties can agree that English law would apply. We don't need to get to the interesting but more difficult question as to whether the court is required to apply foreign law. I'm certainly not suggesting that. If the parties both themselves want the dispute resolved by reference to English law, and as I say, whether we do that by reference to the presumption or the scope for agreement in the regulations is perhaps not important. But I do say that there's no scope for the presumption to be relied on in getting over the hurdle at the merit stage if it is not arguable that English law applies. It would be different if it was arguable that English law applies. But the claimant started applied for
I can't understand that last proposition. How could it be different if the claimant is saying that English law applies, that somehow gives it the right to rely on a presumption in relation to foreign law? If it's wrong in saying that English law applies, are you saying that simply to make a wrong case that English law applies for primary case?
Maybe I didn't express myself very well on that point, my lord, in which case I apologise. What I'm saying is if there is scope to argue that English law applies, that means that a claim pleaded by reference to English law is not bound to fail at that point, because there might be a claim under English law. But in circumstances where it has either been conceded or decided that there is no claim available under English law, and that was the position when the claimant applied for permission to serve out in this case. In that set of circumstances, there is no claim under English law. The only claim that's available is under foreign law. And if the traditional position is to be maintained, that the English court requires foreign law to be pleaded because it is treated as a matter of fact, albeit a fact of an unusual kind, then the pleading needs to plead the foreign law. And simply saying under Egyptian law, but then I'll rely on English law, is not, in my submission, the appropriate way for to proceed. My lord, I'm conscious of the time. I'm very happy to finish Mr. Justice Simon's judgment or to take a short break now.
Why don't we have our 5-minute adjournment just now, and we'll resume very shortly.
Thank you very much.
Yep. I think we're ready to resume now. Ms. Kinsler.
Thank you, my lord. My lord, we were just looking at the judgment of Mr. Justice Simon at EF 1681, and I was just going to take your lordships to a little paragraph C, which is an important paragraph. Mr. Justice Simon says it's not consonant with the overriding objective of the CPR in a case where the 1995 Act applies for a party either to decline to plead the relevant provisions of the applicable law or to rely on a presumption that a foreign law is the same as English law. Such an approach is evasive. There may, of course, be an issue as to which particular law applies, but that is a different matter. The parochial approach, which presupposes that it is inherently just for the rules of English domestic tort law to be indiscriminately applied regardless of the foreign character of the circumstances and the parties, is precisely the mischief which the Law Commission sought to remedy and which was remedied by the 1995 Act. Now, the specific mischief which the 1995 Act was aimed at is, of course, the rule on double actionability. That Act removed the rule on double actionability and replaced it with choice of law rules, which result in the law of the tort being generally the law of the place of the tort, and in personal injury or fatal accident cases, the law of the place of the accident. So that's the mischief that the Act was directed to. But the point Mr. Justice Simon is making is in the context of an argument about reliance on the presumption. And what he's saying is the effect of allowing a party to rely on the presumption in the context where the applicable law is not English law, the effect of that would be exactly the same as the rule on double actionability to apply English law to a foreign tort. And that was the mischief which the 1995 Act was intended to address. And so effectively that allowing the application of the presumption is to subvert the choice of law rule, which actually directs the courts to apply the law of the place, in this case, of the accident.
Of course, it can be very convenient for the parties to rely on the presumption for both parties. And if they didn't, it would make many claims prohibitively expensive to litigate because of the need for expert evidence.
Well, it can be, my lord, and we have no difficulty with that as a possibility. And as I say, it may be that in modern times, the route by which the parties do that is via whether an express or implied agreement under the Rome 1 and Rome 2 regulations. We don't have any difficulty about that, but we do have difficulty about the position where the parties are not agreed and where the claimant bears the burden, as Lord Jones says, whether that's in the context of jurisdiction or an ordinary claim. If the claimant bears the burden and there has been a determination or a concession of applicable law such that foreign law applies, then we say it's not appropriate for the presumption to apply. And as I say, I'm not suggesting that the English court must apply the foreign law dictated by the regulations, certainly not. That would require an enormous change to the position of the English court and the parties' responsibilities and roles, and that's not a submission I'm going anywhere near. But I do say that in circumstances where the claimant has to discharge a burden and the applicable law is not English law, it's not appropriate because the effect of it is to apply English law instead of the correct applicable law. Yes, my lord. Ms.
Kinsler, can the default rule ever apply in the absence of the consent or agreement of both parties? Because if one party asserts that foreign law applies but doesn't assert the content of the law, the default rule might apply in those circumstances, but it would not apply if the other party asserted that the content of the foreign law was different from English.
Well, my lord, I think this is where a distinction may need to be drawn also between proceedings that are on foot where a party is subject to the jurisdiction and a case like this where the court is concerned with the court's jurisdiction over a defendant. Because in a case where the parties are both before the court, then obviously the defendant can put in a defence and take any points it likes in the defence, and indeed can adduce evidence of whichever law it likes also. But the position of a foreign defendant is different. A defendant who is being summoned to the English court is different. We say that the operation of the presumption in that case is particularly problematic because it does impose on the foreign defendant an obligation effectively to disprove the claimant's claim at a very early stage and to incur the expense and inconvenience of adducing foreign law evidence in circumstances where actually the burden's on the claimant. I don't know if I quite answered your lordship's question. I think I may have got slightly lost. So
I think it may have turned into a slightly different point, but I understand your point.
Thank you. My Lord, just to finish on Mr. Justice Simon's judgment, paragraph 142 is referring to the PT Pan case and saying that it's not support for the proposition that the parties in the present case are entitled to proceed on an unreal basis, either that English law applies or that English law is the same as the applicable foreign law. And my Lords, we're going to take the Lordships now to the judgment of the Court of Appeal in this case, which is at 1685. The judgment of the court was handed down by Lord Dyson. That's apparent from 1691, but principally drafted by Lord Justice Lloyd Jones at that point. So 1692, paragraph 1 indicates that. And if your Lordships could turn to 1741.
So perhaps I should say, I didn't write this part actually. So you're taking us to page?
1741.
Thank you very much.
Paragraph 134. This is the section on the applicable law. The precise grounds of appeal, paragraph 29. Mr. Hammer puts the matter in this way. He submits that the judge's ruling wrongly puts the burden on the claimants to plead their case on foreign law when they were entitled to rely on the presumption that English law is the same as foreign law. And then picking it up at paragraph 149. I should probably just pick up at 144 at the bottom of page 1743. Just the last few lines, it's important to note that in this context, Mr. Harmer had conceded an argument before the judge it was unlikely the law of England and Wales applied. This case also was determining the applicable law and determined that it was not English law, but that was the concession. And then picking it up at 149, the Court of Appeal says, we turn next to the issue of the pleading of foreign law and the presumption. Standing back for a moment, it's apparent that the real bone of contention between the parties was not so much whether the issue of applicable law was engaged by the claims, but who should plead their case on the content of foreign law first. And as such is a different aspect of the claimant's case on prematurity. I think the claimants were saying it's too early to determine the applicable law and we shouldn't have to plead foreign law. The Court of Appeal said it's not too early, we'll determine the applicable law. And in relation to pleading, then paragraph 150 on 1745, in the court below, the claimants contended that the pleading of the applicable law should await findings of fact as to what occurred, but in the meantime the case should proceed on the basis of the presumption that foreign law was the same as English law. It was said that in the absence of reliance by either party on foreign law, the court should apply English law. And then picking it up at 152, further down the page, Mr. Harmer submits the order made by the judge was unjust and disproportionate because it forced the claimants to incur the cost, inconvenience and delay of seeking expert evidence on several systems of law when they did not seek to rely on any material difference in foreign law and none was alleged against them. In argument, he said that as a result of the judge's order, the burden had wrongly been put on them to set out their case in this respect. 153, whichever way it is put, we cannot accept this argument. It seems to us to be a wholly artificial and unrealistic way of looking at the case when one considers the nature of the allegations made by the claimants and, of course, the concession made by Mr. Harmer. The claimants advance no authority for the proposition that the applicability of foreign law cannot be determined at the pleading stage in the absence of either party pleading a case, and we reject the suggestion that the timely resolution of the issue by reference to the Act, which is plainly raised on the facts, should yield to the evidential presumption of similarity for what might be described as tactical reasons. And then turning over the page to 155, so page 1746, paragraph 155, we're not surprised the judge was unimpressed by the claimant's arguments on this pleading point, which he characterised as evasive, unrealistic and contrary to the overriding objective. We would add that we do not accept that Section 14(3)(b) of the 1995 Act, which provides a saving for any rules of evidence, pleading or practice, affects the position, as Mr. Harmer argues. The issue of the applicable law is one of substantive law, not procedure. And I do stress that. Whereas it might be thought to be self-evident. The law which defines the rights and obligations of parties determines the scope and basis of those rights and obligations, and it is very much substantive law. But the Court of Appeal is here emphasising that point in response to an argument that actually is all about pleading and evidential presumptions. The Court of Appeal says, no, it's not. It's about applicable law. And that's really, I suppose, at the heart of our case, that this is all about applicable law. And in circumstances where the applicable law is foreign, to apply the presumption is to circumvent the choice of law rules and to apply English law in place of foreign law. My Lord Legate?
Is one possibility that it's simply an evidential presumption, and that, say in a case where the applicable law is Australian law, one might start from an assumption reasonably that it's going to be the same as our common law, let's say. That might be a reasonable inference without evidence, unless the contrary is shown. Or if a claim, say, is for torture, you might start with a reasonable inference that any system of law is going to give a cause of action for being tortured without having to adduce chapter and verse, unless issue is going to be taken with that. But if, say, there might be, if on the facts that isn't a reasonable inference, because it might well be that the foreign system won't be the same, then it might not be sufficient to rely on in the absence of anything else. That one possible view.
Yes, my Lord, the Court of Appeal in Shaker, I think, made it quite clear that certainly that court's view was that the similarity or otherwise of a foreign law system, or indeed whether a rule might be universally applicable, was not relevant to the application of the presumption as a matter of principle. One could see that there might be thought to be less difficulty with the application of the presumption in the context of a foreign law which was known to be very similar to English law. And the cases do show that one of the factors in whether the presumption does apply is whether the court has reason to believe that it is different, the foreign law is different, and that can arise either because the court has some evidence of foreign law, as the court does in this case, or for some other reason the court may believe that the foreign law is different. So one could see that in circumstances where it is appropriate for the presumption to apply, that the known or suspected similarity of the foreign law might be a relevant aspect in deciding whether the presumption could operate, but that would be within the scope of the operation of the presumption. But in my submission, that doesn't undercut in any way our case that on an application for permission to serve out, the claimant needs to have a viable claim pleaded against the foreign defendant. The foreign defendant needs to know what the claim is that's being brought against it. And the presumption, the application of the presumption in that context is not appropriate. Yes, my Lord Burrows.
While you've raised that point, can you just explain to me precisely what it is that you don't know about the claim against you, that is, that has not been pleaded?
So, my Lord, we don't know. As I said, the evidence before the court is that Egyptian law is a civil code-based system. There are there's a civil code and there's also specific codes, and under each of those codes, different obligations are imposed on parties, and those obligations carry with it different types of conditions and preconditions. So, for example, the evidence on the contract claim under the commercial code shows that the liability under that code is strict, and it defines the circumstances in which it applies. The evidence shows that there's a potential claim in vicarious liability and tort, and the claimant's expert sets out the requirements for that claim on vicarious liability and tort, and they're not identical, the facts that need to be shown to establish vicarious liability in Egyptian law as in English law. What we submit we are entitled to is a pleaded claim setting out, by reference to whichever codes the claimant relies on, the specific code and the cause of action that's relied on, and indeed the facts, the actual facts separate from foreign law, which would need to be established to give rise to liability under those specific codes.
I think you earlier referred to a distinction between the content of the law and the source of the law. Now, the answer you've just given would indicate that you are relying on saying that it's inadequately pleaded because you haven't been referred to the particular codal provisions, as opposed to what one might say at first sight, that you've been told the claim against you is for negligence, that is breach of a standard of duty of care. It makes no difference then whether it's strict or not, because if it was strict, that would be even easier for the claimant to prove. You've been given the bare contents that this is a claim both by the claimant in her personal capacity and for her own injuries, and in relation to losses she's suffered on behalf of, or what one might say, the estate's loss. And you've also been indicated that the claims are being brought both directly and in relation to vicarious liability. So in terms of the content, it's not clear to me what else you actually need. So does it become the proposition that actually what needs to be pleaded are the codal provisions?
Well, my lord, I certainly didn't intend to confine myself to referring to the sources of the obligations. I was trying to answer your lordship's question sort of fully, but it is those sources, the identification of those sources then tells a party something about the nature of those obligations. And obviously, if they are set out, the actual obligations without name checking the specific provision, that would be sufficient. It is important nonetheless for the specific cause of action to be identified. It is problematic for all sorts of reasons, including limitation, if the specific obligation isn't referred to. In this case, I represent an Egyptian company, but in the claim against FSHI, it was a Canadian company was being sued on the basis of Egyptian law. And so it is important for the foreign defendant to know specifically what the claim is made against them. And so I do say that the authorities do support this, that it is important to plead the sources of the obligation, but the key is obviously the content of the obligation, but it does need to be sufficiently precisely identified so that the party knows what the claim is that's being made.
But why isn't it sufficient that you know that the claim against you is a claim in contract and tort of a standard of reasonable care?
Well, my lord, we don't know if such, and the material before the court is such that we don't know if there is such a claim in Egyptian law under contract, for example. And so the claimant has to say what the claim is. And so the pleading is pleaded by reference to English law on a conventional, as it were, basis, by reference to English law principles of implied duty of reasonable care. But we do not know that such a claim exists in contract law, in Egyptian law.
Well, I don't understand what the problem is. If you're acting for an Egyptian company, if they're lawyers in Egypt, well, they're in the best position to tell you if there is no such claim in Egyptian law, and if there isn't, then you deny that such a claim lies, and you begin with defence.
But my lord, foreign law has been always treated in the English court as a matter of fact, which has to be pleaded. And there is no foreign law pleaded in this particulars of claim. The facts which give rise to a cause of action in English law have been pleaded, but we would say that there is no pleading of foreign law. And indeed, in relation to, for example, the vicarious liability claim, the relevant facts are not pleaded in relation to what the expert evidence says is required for the claim of vicarious liability. And so in those circumstances, we say there is no viable pleaded claim unless the position is that English law, that the foreign law no longer needs to be pleaded. There is no viable claim on the pleadings. It's obviously possible that the position could change, and if foreign law doesn't need to be pleaded and it's pleaded and it's adequate for a claimant simply to plead the claim by reference to standard principles of English law and assert that there is a contract or a claim in negligence based on a standard English approach, well, that's one possibility, but that's not the approach that the English court has taken to date. The English court has required a party who relies on foreign law to plead that foreign law. In addition to pleading the facts which would give rise to that liability under that foreign law. My lords, I think we were in the Court of Appeal's judgment in Belhaj, and I was submitting that it was important to focus on the fact that the issue of the applicable law is one of substantive law, not procedure, and that the effect of permitting reliance on the presumption is to disapply the choice of law process and the substantive law which applies as a result of that process. And in my submission, the presumption should not be deployed to circumvent that reality. Picking it up at paragraph 156 of the judgment of the Court of Appeal, which is EF 1746, the judge said that the observations of the court in PT Pan were not part of the court's reasoning. Even if they had been, they were of little assistance since no foreign law had been advanced in the present case. And the decision certainly provided no support for the proposition that the parties were entitled to proceed on an unreal basis that English law applies or that English law is the same as foreign law. We agree with that view. In our conclusion, in view of our conclusion, it's not necessary to address some of the broader issues potentially raised by the defendant's arguments on the presumption, including the criticisms made of it in the modern world of pleading in practice, which Mr. Phillips touched on, except to say that in our view, the presumption of similarity is not one which in any event applies inflexibly regardless of the circumstances and is subject to a number of exceptions. One exception must be where, as here, the issue of the applicable law is plainly engaged on the pleadings and on the facts, and the court is in a position to adjudicate on the point. And that's important, and that's why I've been focused on the fact that the issue of the applicable law here is plainly engaged. It's accepted by the claimant that the only available claims that she has are under Egyptian law. And then 158, the inevitable result of all this is that the claimants will have to plead their grounds for asserting that the conduct alleged is unlawful in accordance with the judge's order. If they do not do so or fail to prove their case on the point, their pleading will be deficient and their claims will fail, subject, of course, to the important public policy exception. This is no more, no less than is appropriate in accordance with the ordinary rules of pleading. that judgment is in the context of the 1995 Act, so it is different from the earlier authorities in the context of the double actionability rule. And in that context, I do submit that it's very important that the Court of Appeal has recognised that the question of the presumption is not just a question of procedure and evidence, but it is a matter of applicable law. And in my submission, the position is exactly the same in that sense under Rome 1 and Rome 2. The basis for the claim is the applicable law, and the legal basis for the claim is not English law, it is Egyptian law, which is why Mr. Donovan, her solicitor on her behalf, is quite correct to say that the only claims she can advance are those available under Egyptian law. My Lords, I was going to take your Lordships next to the Court of Appeal judgment in Oppo, which is at 2299. This was the judgment in the case of a claim for an interim injunction to stop publication of a book. The claimant relied on the principle in Wilkinson and Downton, alleging intentional infliction of mental suffering. The first thing to note is there was an issue about the applicable law. So it's a judgment of the Court of Appeal. It was Justice Arden, Jackson and Lord Justice McFarlane. Paragraph 9.
Cases that came to the Supreme Court.
It is, my Lord. My Lord, but this point was not addressed in terms. I will take Lordship here. Paragraph 95, which is on page EF 2321. My Lord, Lady Justice Arden, I think given the judgment of the court, says there is an issue about which law applies to the alleged wrong by the respondents. The choice is between Ruritanian law and the law of England. Unless Oppo can show that the proposed publication of the work is likely to be wrongful as a matter of the applicable law, he will fail to satisfy the requirements of Section 12. That's Section 12 of the Human Rights Act, because the injunction was affecting freedom of expression. The claimant had to establish that the publication would be wrongful as a matter of the applicable law. The applicable law was determined by Rome 2. Your Lordships will see at 97, applying Article 4.1, the proper law in this case is that of the country which the damage occurs, which in this case would be Ruritania. However, by Article 4.3, where it's clear from the circumstances of the case the tort is manifestly more closely connected with another country, the law of that other country shall apply. So there was an issue about whether Article 4.3 applied, and your Lordships will see that at 112, Lady Justice Arden addresses that question, whether Article 141 should be disapplied by 4.3, and she holds that, in my judgment, it's likely that English law applies. So that's the starting point for this case, that English law was held to be likely to apply. But in addition to arguing that the applicable law was not English law, the publisher also argued that in the absence of evidence of Ruritanian law, the claimant's claim should fail and the presumption could not be relied on. And if your Lordships look at 2322, paragraph 101, that's where this submission is then addressed. You'll see at 99, Mr. Jacob Dean for the publisher has 4 points, and then first is the applicable law. Second, Mr. Dean submits that the absence of evidence as to the law of Ruritania is fatal to this case. He relies on the observations of Mr. Justice Gray and Mr. Justice Simon in Belhaj, where Article 4 applies, and that where Article 4 applies, a party must bring forward evidence on foreign law and cannot simply rely on a presumption that in the absence of evidence, foreign law should be assumed to be the same as English law. Picking it up then at 104, I'm so sorry, 108. The first question is the effect of Article, so 108 is on 2323. The first question is the effect of Article 4.1 in this case. I do not accept the submission that even though there is no evidence as to Ruritanian law, the presumption that foreign law is the same as English law does not apply. That is a rule of evidence applied by the English courts. As such, it is not affected by the regulation. My Lords, it's true that Rome 1 and Rome 2 preserves procedure and evidence for the forum. But in our submission, Lady Justice Arden is wrong to say that the presumption is a rule of evidence. This judgment, I think, was handed down 2 weeks before the Court of Appeal's judgment in Belhaj. And in that case, as we just looked, the Court of Appeal, specifically in the context of the 1995 Act, held that the question of the presumption was not a question of procedure or evidence, which came within the exception in Section 14. And so these two judgments don't sit happily side by side. And in our submission, there's no question that the presumption, for the reasons I've explained, is not just a rule of evidence. It does actually distort the application of the applicable law in its effect. My Lords, Lady Justice Arden then continues. She refers to the Law Commission's report, which led to the 1995 Act, recommended the choice of laws. The choice of law. The Law Commission's report, which led to the 1995 Act, recommended the choice of law rules, which it recommended should not apply to rules of evidence. That is reflected in Section 14(3)(b). That's the point I was just making. That was the specific provision that was looked at in Belhaj in the context of the presumption, and the Court of Appeal held that did not apply, or it did not. The presumption was not within the scope of that. And then she refers to the observations of Grady in Al-Misnad, and says that he clearly accepted the applicability of the presumption in the context of choice of law rules. But again, that was in the context of a double actionability claim, not a claim under the 1995 Act or Rome II. And then 109, in Belhaj and Straw, the second case on which Mr. Dean relies, the observations of Simon J. were obiter, since he went on to find the cause of action were non-justiciable. And then she reads out the passage that we've already looked at in Mr. Justice Simon's judgment, and then at 110 makes a number of points in relation to it. So first of all, the mischief to which Lord Justice Brooke referred was one caused by the English choice of law rules, not one caused by the presumption that in the absence of evidence as to foreign law, it should be treated as if it were the same as English law. Well, that's true, but as I have already submitted to your Lordships, the application of the presumption is to the same effect as the double actionability rules. English law is applied to the foreign tort regardless of the foreign connections, and so the impact is the same. Secondly, Lady Justice Arden says the overriding objective of the CPR does not require a party to plead a case on which he does not rely. And we do focus very clearly on that, those words. That's correct. But in this case, the claimant does rely on foreign law because the claimant has to rely on foreign law because it has been held that there is no available claim under English law. Thirdly, it's not clear what sanction would be available if it was a breach of the CPR to fail to plead the proper law on which a party did not rely. My Lord, the sanction that would be available, there would be two options open to the court. Either the claim would fail because there was no viable claim, or the court could order the claimant to amend the pleading and replead the claim. That was the position in Belhaj in the Court of Appeal. The Court of Appeal said the claimant must plead their claim by reference to foreign law, otherwise the claim will fail. That was Lord Justice Arnold's position in this case, that on the vicarious liability claim, for which there is evidence, he would have ordered that the permission was subject to a condition that the claim be pleaded by reference to the foreign law. So the sanction is that if there was a failure to plead, the claim would fail. Fourthly, this paragraph has to be read in the light of the judgment of Simon, referring to the fact that the court of a first instance cannot ignore the rule that in the absence of evidence, foreign law is the same as English law. Lady Justice Arden goes on, there's no discussion in the judgment of the important restriction on the presumption which would result if that were the effect of the regulation, or the 1995 Act, nor is there any indication in the 1995 Act or the regulation as to what the court must do if there's no evidence as to foreign law. In my judgment, it's clearly a matter which has been left to be resolved in accordance with the rules of the forum. And Lady Justice Arden then refers to a passage in Dicey and Morris in the supplement, and says, accordingly, I do not consider that the observations of Mr. Justice Simon should be taken as supporting the proposition for which Mr. Dean has cited them. That section of Dicey and Morris, which Lady Justice Arden there refers to, is the section on defamation. And defamation is, as your lordships know, subject to double actionability. I took your lordships to the section in Dicey and Morris, the general section on proof of foreign law, which is chapter 9. And in my submission, that is the important part of Dicey and Morris on this point, and the double actionability considerations are different. There's no discussion in this case of some of the other authorities that we've looked at. So there's no reference to Shaker, the Court of Appeal's important decision in Shaker, of which Lady Justice Arden was on the court in that case also. This case, as my Lord Reid pointed out, was appealed to the Supreme Court, but it was argued on the basis of English law. For your lordships, note, or we could turn it up, it's the Supreme Court's judgment is at 4500 of the bundle. Just to complete the point. 4500, and it's the judgment of Lord Neuberger at paragraph 121. Just temporarily lost my reference, but it's the paragraph 121 of Lord Justice Neuberger's judgment.
I think we're looking for 4542.
4542. Thank you, my lord. Oh, that's absolutely right, my lord. Thank you. Lord Neuberger says the final point I should make is that this case has been argued in the court on the basis that the issue between the parties has to be resolved owing to English law rather than the law of the US where the claimant resides. It may well be that's right. That is right, as the Court of Appeal held, or that even if the US law is in fact applicable, it's the same as our law. So the Court of Appeal had held that it was English law that applied, and that law was then formed the basis of the Supreme Court's decision. So the Supreme Court doesn't deal with or address the question that Lady Justice Arden had been addressing at in the Court of Appeal. My lords, in Brownlie against FSHI in the Court of Appeal, this issue was also argued. The reference is 1801. At 1822 in the judgment of Lady Justice Arden. Uh, 1822, paragraph 88. So Lady Justice Arden has just concluded that the law applicable to the claimant's claim is English law. So that was the Court of Appeal's view that it was an English law claim. That, in fact, then the Court of Justice decision in Lazar came after the Court of Appeal judgment, and that made it clear that it was not an English law claim. And from that point on, the claimant conceded that there was no claim under English law. But picking up to 88, the remaining question is whether this court can, under Rome II, in the absence of proof as to Egyptian law, apply the presumption that Egyptian law is the same as English law. I would reject Mr. Palmer's argument on this, and then refers to the passage we just looked at in OPPO, and then paragraph 89, the case went to the Supreme Court, who reversed the decision on the other question, and then the legislator refers to that paragraph we just looked at. and says that Lord Newburgh specifically accepted the presumption could be applicable. I'm not sure he goes quite as far as that, but he does certainly refer to the fact that US law might be the same, English law applied, but US law might be the same as English law. And then just reading down, I accept Mr. Palmer's submission about that OPPO is not binding. However, Mr. Palmer did not seek to address the point I made in paragraph 111 of my judgment, as that there's no indication in Rome 2 as to what a court must do if there's no evidence as to foreign law. In a common law system such as that in England and Wales, the court does not have any inquisitorial function and cannot conduct an inquiry itself as to foreign law. Even if it did, it might not come to the right conclusion. If Mr. Palmer's argument is right, it would follow that the court could not act on any agreement of the parties. These seem to me to be startling conclusions. And just stopping there, the position is quite clear that as I submitted earlier, that under Rome 1 and Rome 2, the court can act on the agreement of parties as to the applicable law. So that's, that can be put on one side. And the Lady Justice Arden says there's no indication in Rome 2 as to what a court must do if there's no evidence of foreign law. Well, that's quite correct, because it's left to the national courts to decide. And as your lordships know, different national courts take entirely different approaches to foreign law. The English court's approach at the moment is, in the absence of foreign law, to apply the presumption. But that's why I said earlier that the context is very important. So it might be that if a party does not, either doesn't take a point on applicable law, or takes a point but then doesn't plead its case under the foreign law, if both parties are before the court, that's one set of circumstances. The situation in which one party is outside of the jurisdiction does change the picture in my submission. But certainly our argument on the presumption does not impact on the possibility of parties proceeding to a trial in this country based on English law, even if the applicable law is foreign law. We are not suggesting, as I said, that there would be a requirement for the claim to be resolved by reference to foreign law if parties consented to that position. Lady Justice Arden then looks briefly in 90 at Shaker, which was relied on by Mr. Palmer. So just under F, Mr. Palmer went on to rely on Shaker, where this court held that a mandatory rule in the Companies Act could not apply to a company incorporated in another jurisdiction. That case, however, concerned a rule about the need to have relevant accounts, which applied to companies incorporated in England, but which by its nature could not realistically be assumed to exist in foreign law. Your lordships will recall that actually the Court of Appeal said it wasn't relevant to look at whether a particular rule might exist in the foreign law. But the key was in Shaker that the English court should not adapt. There was no scope to adapt an English statute to apply to foreign law. So that takes us back to just before we get to the Supreme Court again in Brownlie. There are a number of other cases which I don't have time to take your lordships to, but I'll just make some short points on them. So there's a decision, a Court of Appeal judgment, Parker and Toohey, which is at 2327 of the bundle, and the relevant section is 2332. In which the Court of Appeal in one paragraph dismisses a submission which is made for the first time in the Court of Appeal that a claim should fail because the claimant had not pleaded or proved the foreign law. And Lord Justice Longmore, I think, refers to that being a breathtaking submission. But in my submission, it is a one-line affirmation of the presumption, but there was no argument or authority cited to the court. In Erste Bank, the Court of Appeal looked briefly at the question of pleading of foreign law, as had Mr. Justice Flew, as he then was at first instance. The references are 2031 and 1956. But that was a case, again, where the claimant's primary case was that English law was the applicable law. And there's dicta on the pleading, there's no argument addressed to the presumption. At first instance, the decisions relied on by Mr. Justice Flo it's a decision of in Kuwait Oil, which was in the context of double actionability. So I say again, very different. Coming back then to Brownlie in the Supreme Court, Brownlie FSHI in the Supreme Court, that decision in my submission is important and is on not on exactly the same pleadings as are current for the court, but on the pleadings which are materially the same, because the pleadings before the court at that point relied solely, they pleaded all the content that's still there about the facts and the implied duty of care and the basis of the contract and the negligence, but they did also plead reference to the acts, the Fatal Accidents Act and the 1934 Act. And the Supreme Court held that there was no prospect of success for the claimant's claim for loss of dependency based on that pleading. We didn't argue about evidence because there was no evidence of Egyptian law before the court. And in my submission, if the Supreme Court had thought that by striking through the reference to the acts and leaving the pleading intact, other than the addition of pursuant to Egyptian law, if the Supreme Court had thought that leaving the pleading as it was without reference to the acts was sufficient, they would certainly have, I would have anticipated they would have said so, because we had the argument to that effect, that the pleading as it stood was sufficient for the claimant to rely on the presumption, even if the act didn't apply as such. And in my submission, adding the 3 words under, or pursuant to Egyptian law, 4 words in fact, pursuant to Egyptian law, does not cure the pleading, and reliance on the presumption cannot cure the pleading. The foreign law is a matter of fact and needs to be pleaded as well as proved. If I can just summarise the principles that we derive from the authorities very briefly. Firstly, that foreign law is a fact and needs to be pleaded and proved. Secondly, that the presumption has always had limits. It cannot operate, firstly, if the foreign circumstances are outside the scope of English law. And that's particularly so in the case of statutes. And so Shaker is one example, and Brownlie FSHI is another example. And there's no basis for adapting the statute to fit the foreign case. Secondly, the presumption cannot operate in favour of a party who bases their claim on foreign law, because in such a case, that is the basis for the claim. And the authorities which permit the presumption to operate are where a party does not rely on foreign law. So Oppo in the Court of Appeal, Erste Bank. I haven't taken your lordship to the first instance decision in Iranian offshore, but again, that was a claim where the claim was advanced on the basis of English law. But there are no authorities which support the operation of the presumption where the claimant relies on and bases their claim on foreign law. If the court the third circumstance in which the presumption cannot operate is if the court has evidence or other reason to believe that foreign law may be different from English law. And particularly, we would say if a party has, the party relying on foreign law has adduced evidence of foreign law, there should be no scope for the presumption to fill the gaps that evidence might have left. And fourthly, even within the potential scope of operation of the presumption, there are many recognised exceptions, and it may be inappropriate to permit reliance depending on the legal and procedural context. And we say that in the context of an application for permission to serve out, permitting reliance on the presumption should not be permitted. Firstly, because it alters the law applicable pursuant to the choice of law rules. Whatever terminology we use, whether we use the presumption terminology, let's say that foreign law is the same as English law, or whether we use the default rule, let's apply English law in the absence of evidence of foreign law, whichever terminology is used, the result is to apply English law. And that tells the court, that shows why it's a question of substantive law. It's not just about procedure and evidence. Secondly, it defeats the purpose of the merits test, and we do submit that the merits test has to be applied on a realistic and true basis. There's no point in the court applying the merits test by reference to a law which does not apply. And thirdly, the presumption reverses the burden of proof, which is squarely on the claimant. My Lord, I'm conscious of the time. Those are my submissions on the law. We say on the basis of the authorities and as a matter of principle, the claims as pleaded are bound to fail because there is no claim under English law and no other claim has been pleaded. My Lord, we do, on the evidence, our position is that the Egyptian law evidence, as held by the Court of Appeal, the evidence demonstrates only that there is an available claim based on vicarious liability in tort. There is no evidence before the court of an available claim in contract or direct liability in tort. And in those circumstances, quite aside from the pleading point, the claim does not have, the claims in contract and direct liability in tort do not have reasonable prospect of success. The court cannot be satisfied that there are reasonable prospects against the defendant based on that evidence. And it would not be appropriate to allow the claimant to rely on the presumption to fill the gaps and get over the merits hurdle in the circumstances.
One point with you, Ms. Kinsler. Is it right that the clause, the section in an Act of Parliament which specifies the extent of its application is a bar to the presumption applying to statutes, because the application clause will obviously say this Act applies to England and Wales or Great Britain or the United Kingdom. It's not going to apply to Egypt. And if that's a good point, then effectively statutes fall outside the scope of the presumption. Personally, in Dyson-Morris, the chapter which deals with the presumption also deals with the rule that at common law, British colonists took English law with them to New South Wales, for example. And that rule applied to statutes as well as the common law. Now, obviously, Parliament, when it passed an act for England, or indeed the UK, if we're talking about New South Wales, it wasn't legislating for Australia at all, but nonetheless, that wasn't a barrier to the application of a common law rule, giving the statute an extraterritorial effect, evidently ignoring any implied or expressed limitation of its territorial application, which the Parliament had intended. Now, could one not equally apply the presumption? I mean, effectively, territorial application clauses can't coexist with the presumption if the presumption is to apply to statutes. You say the consequence is the presumption has no application to statutes. The contrary view would be, well, you have to disregard the territorial application clause.
Well, my Lord, that's why we rely on the Supreme Court's judgment in Cox, because in Cox, the Supreme Court expressly looked at the question as to whether the Fatal Accidents Act could have extraterritorial application.
No, you're missing the point. That nobody's arguing that the UK statute has executorial effect. The question is whether, for the purpose of applying the presumption, you ignore the limitation on its territorial effect which the statute contains.
Yes, I mean, you either ignore the extraterritorial, the territorial restriction. So, by or through the prism of the presumption, you effectively adapt the statute to apply to the foreign circumstances. So that's what you would be doing if you were removing the territorial restriction, or you are simply applying English law as English law, as it were, without regard to the foreign circumstances. And in my submission, whichever analysis the court adopts, that's not it's not permissible. It's not permissible on the authority. Shaker makes it clear that acts should not be adapted, and if you don't adapt it, you can only apply it as English law. But the choice of law rules dictate that English law does not apply in this case.
Yeah, Shaker seems to be the high watermark.
I'm sorry, Madam.
Shaker is really your strongest authority, I think, isn't it?
Well, only on the act point.
Yeah.
Absolutely. I think Dyson Morris picks up the point that the court shouldn't. It's not appropriate for the court to extract the gist of a statute or assume that there's some universality about a principle in a statute. But yes, the key authority on the statute is Shaker, and then that was effectively as applied in Brownlie FSHI, we would say.
Yeah.
My Lord, I think I've come to the end of my submissions, and I'll hand over after the adjournment to Mr. Palmer. Could I just say, just before I do finish, is that the appellant for whom we act has been a party to these proceedings since 2019. And my clients would like the court to know that, albeit that jurisdiction has been challenged, they have engaged fully and positively with ADR with respect to the claim as a whole. The Court of Appeal hearing was stayed to enable the parties to pursue ADR, but unfortunately no resolution was achieved. But I did want to just make that clear to the court before I brought my submissions to an end. So unless I can be of any further assistance, those are my submissions.
Thank you very much, Ms. Kinsler. We'll adjourn now and resume at 2 o'clock.